Bonjour and welcome back. This is the first of two videos discussing statutory interpretation in the context of the common law. The second video will try to give you a big picture and make some comparison with civil law systems. Here, the focus will be on the context of the development of statutory interpretation in common law systems, because this context is really important to appreciate the finesse or the tensions or the problems that exist to these days regarding interpretation of statutes in the United States and other common law jurisdictions. And of course, we will address the methods of interpretation that are used in these jurisdictions. This visual shows you the big trend in a common law jurisdiction. It is a sort of, see it as a timeline. The starting point, as we have seen covering the historical development of the common law, was the predominance of case law. Judges, courts were the strong engine for the creation of the law, and we can fairly say that case law, be it common law or equity, has dominated the stage till way towards the end of the 19th century, at least in England, but also largely in the United States. We then have a period where legislation starts developing in England that was due to a codification process, which meant actually putting in one codifying statute some big chunks of the law, especially in areas of business law, such as sale of goods, partnership, bills of exchange. And the whole idea was to make the common law more accessible to the English colonies, where they didn't have full libraries with law reports. This codification movement has somehow existed in the United States in the 19th century. We have addressed that earlier, but it is a different story. But we can say that during this period, you see that in the English colonies of North America and in the independent United States, more and more legislation appear, and you have a sort of competition between the courts and the legislature as an engine of development of the law. And the third period, which is the present period, I would put the start after World War II, is the age of statute. We are now at a time where statute really predominates. We see legislation on almost everything, including in areas that are still to this day regarded as traditionally case law oriented. I'm talking here about torts and contracts, to name parts of the law that you are already getting familiar with. And of course, you see this evolution, the fact that the system moved from predominantly case law to predominantly statute law has had, as we will see, a large impact on the development of statutory interpretation. The first period where case law predominates sees interesting development regarding interpretation. When did legislation intervene in England during the late Middle Ages or Renaissance period or Classic period? Legislation was unusual in those days. Statutes were a rarity. Actually, the statutes we had at the time can be called remedial statutes. It is when the common law got stuck because of its rigidity. Equity helped, but to some extent, but did not fix the problem completely. Parliament was every now and then passing a remedial statute. And remarkably, English courts at the time looked at these statutes as a way of bringing help, you see, to move the system forward. And they looked at it with a rather flexible eye, and the courts were willing to look for the equity of the statute, which means what is it that the statutes aim at remedying? And let's try to give an interpretation that targets the problem and favors the solution of the problem. So it was a sort of cooperation, if you will, with the parliamentary work, which was, I insist, exceptional in those days. One big method of interpretation came out of this, and it is known, at least in English law literature, as the mischief rule. The idea is that the statute was there to correct some mischief, some defect, some inconvenience of the common law and equity, as if the statute was a sort of patch to hide a hole or a gap in case law. And courts would engineer their interpretation in such a way that the patch would be the least visible. And so they were really trying to see, okay, let's try to identify the contour or the scope of the gap and make sure that the gap is covered, but don't go any further because you don't want this to be too visible on the development of the law. So look, they look for the purpose, but they nonetheless try not to overdo, the interpretation of the statute and restrict its ambit to the problem that has been identified. The discussion of that first period is, of course, focused on England because we're talking about a period when the common law existed in England but had not yet been exported to the future colonies. It starts being exported, but I won't go too much into historical details there. Let's move to the second period where you see a competition of case law and statute. I'll first discuss things in the context of England, and I will move then to our part of the world. During the late 19th century, because of this codification process that took place in England, and due to the fact that legislative intervention was getting more commonplace, the court started worrying and said, hey, we are losing traction. It seems we have a big competitor out there. And Parliament was invading a province that was till now dominated by the courts. And the court's reaction was to try to resist the invasion and restrict the ambit of statutes, interpreting them literally, grammatically, as we are going to see. And this went quite far. And here you will understand why I don't want you to discuss the exegesis method in the civil law as literal interpretation. You want to see where literal interpretation leads you to? Let's get there and look into the literal rule. I have here a quote from a judgment. The author of the quote will appear. If the language of a statute be plain, which means if you have clear language, admitting of only one meaning, the legislature must be taken to have meant and intended what it has plainly expressed. Nothing extraordinary there. We have seen that in the context of the civil law. Interpretatio cessat in claris. You don't need to interpret a clear text. Yes, but wait. Whatever it has in clear terms enacted must be enforced, though it should lead to absurd and mischievous results. You think there might be a typo here, but I know you have read that in the material and you can double check. Even if it leads to absurd or mischievous results, you will go by the words of the statute. At courts, this is a quote from Lord Atkinson, But Lord Halsbury, who was the Chancellor in the late 1800s, said that the courts have nothing to do whether the legislature is doing an absurdity. It is their problem. We accept the superiority of statute law, we will apply it as is, period. And then they would go look at the party and say, too bad. Parliament would not have stepped in. We would have solved the problem based on our case law. The solution would have been much better, but we have to bow to the sovereignty of Parliament. They are the principal lawmaker. We bow to what they say. We are not going to second guess their intent. The text is clear. We apply it as is. If you have to complain about an absurd or unfair result, well, vote these legislators out, press the Parliament to adopt a better solution. By the way, in this context, citing to records of parliamentary proceedings was not even permissible. It was, the judges said, we don't do with politics. You know, this is a political record. We don't want to mess with that. The text is clear, we apply it, period. This is what literal interpretation really means, okay, in the common law context. And interestingly, in England, and to some extent also in the United States, the literal rule has not disappeared and is still applied, particularly in the tax law. And I have here again Lord Atkinson in another case, in Almond Investments, who said that it is well established that one is bound in construing revenue acts, so tax legislation, to give a fair and reasonable construction to their language without leaning to one side and the other. That no tax can be imposed on a subject by an act of Parliament without words of it clearly showing an intention to lay the burden upon him. So whatever they are doing, the fiscal legislation, it is strict interpretation, no second guessing, and you're going to resist doctrines by the tax authority, say, oh yeah, we wrote that, but we intended this. And by the way, we have had here among our alumni, US Senator Russell Long, and the holder of the Russell Long chair, who during 30 years has been fighting for the American people and advocating the strict interpretation of statutes and saving his fellow Americans millions or billions in tax. So this remains a prevailing method in some areas of the law, and it's a good way for the judge to control the work of the legislature. The Brits always have a sense of humor, and whenever judges resist, you know, some extensive interpretation of a statute because there is a blunder out there or a deficiency in the drafting, they will say, well, Parliament in their wisdom have legislated that way. We are not going against that wisdom. This is very ironical, of course, when they refer to Parliament in their wisdom, understand that they point to the lack thereof. So this literal interpretation, which developed in a historical context of rivalry between the courts and Parliament, has largely disappeared, but not completely. And it's pretty good to keep it in some areas of the law to protect actually the citizens in some circumstances. However, an attempt has been done already during this second period of competition between the courts and the legislature. A golden rule was promoted to soften a little bit the harsh results of the literal rule. And here again, you have a quote from a great judge of the 19th century. I really admire. I mean, him alone has developed large segments of commercial law, Lord Blackburn, and I have written a book, though in French, on English commercial law. Blackburn said, in essence, that when you have an interpretation problem, take the whole statute together, construe it all together. You know, your problem may be in one provision, but look at other provisions, well, in peri materie, as we do in the civil law, okay? And just try to fix and avoid that absurdity or inconvenience, okay? So yes, you have to give the words their ordinary signification, but stop doing this when so doing would produce an inconsistency or an absurdity or inconvenience. And looking at the statute as a whole, take the best meaning that fits in the circumstances, though this may not be the predominant meaning. It may not be meaning number one or number two in Merriam-Webster, but maybe number 4 or 5. So yeah, this is worth gold. Okay, the rule has a beautiful name because it is, at last, you see, making judges a little bit more cooperative with the legislature. So to wrap up on this second period, you see that the plain meaning rule is predominant. You see a strong tendency to textualism. You see the predominance of restrictive interpretation, with the few exceptions that are allowed when you apply the golden rule. You see that the courts bow to the superiority of the legislative power and accept that statute has to prevail over case law, but they make no effort or little effort to cooperate with the invader. Okay, there is no collaboration, the infamous word in the French language, if you think of World War II. No, let's resist. And lack of cooperation or minimal cooperation is the dominant factor during that period in England, but also to some extent in the United States. I come now to the third period, the age of statute, which starts in the 20th century, and it becomes really the truth after World War II. Legislation is now ubiquitous. Wherever you look, you see statutes. Legislation is everywhere, and yet it has not developed in a comprehensive manner. What do I mean here? The attempt, the project was not to do what has been done in the civil law tradition and put all the law into writing. No, it was an addition and addition and addition to statute to remedy here and there where the courts seemed to be unable to address the problem. So we're still dealing with remedial statutes in a sense. And so statutes mushroom wherever it is needed, no big plan to codify, with a few exceptions. We've discussed the California Civil Code in the historical videos. You have also the exception of the Uniform Commercial Code, which is a little bit more comprehensive. But you know, Americans are not very comfortable with the UCC. I think that's a little bit too much. And look at the literature of the UCC. It is more criticized than liked. So there is no effort to plan and organize this legislation. Legislation is all over the place. It is detailed. Okay, some codes exist or compilations exist, but if you look at the US code for federal legislation, it's organized by topics. Some states organize either by topics or alphabetical order, but it's just to make the law more accessible. There is no plan of codifying as we have seen in the civil law context. And this is making interpretation tricky and complicated, as we will see. To make sense of it, resort to legislative history has become an acceptable practice. This started in the United States in the 1920s, 1930s. England has resisted it till the 1990s. until that time, it was improper to cite the records of parliamentary proceedings, but it is the influence of European law, the law developed by the European communities and later the European Union, that is purpose-driven and written in more general terms, that has pushed the English court to accept that, yeah, it makes sense to look in the record of parliamentary proceeding to go a little bit beyond mere literal interpretation and try to make sense of statutes and remedy some drafting defect. And by the way, this trend is likely to continue after Brexit. I don't see why English courts would come back to their old traditional view, because after all, the driving force is the fact that we have moved into an age of statute. Another point during this age of statute, we see the purposive method or the purposive approach to gain traction, first in the United States and then also in England. The place where purposive interpretation has developed in the United States is primarily regarding the interpretation of the Constitution, which is not surprising because our Constitution resembles a civil code. It's drafted in very general terms. You have lots of open-ended words like equal treatment, due process, that need interpretation. You've got to project meaning. To give you an example of purposive approach or use of a more modern method, the fact that the Supreme Court has developed a concept of substantive due process derived from the 15th and 14th Amendment is pretty much purposive, really trying to expand the concept of due process beyond what is purely procedural. And you know that in a common law context, we have discussed that already, the boundary between procedure and substance is sometimes fuzzy, okay? But of course, that purposive approach has gained also traction in the interpretation of legislation itself, not only the Constitution. It is meeting, however, some opposition. And the opposition of the originalist movement, and Justice Scalia was a good example of that. He was insisting that, be it the Constitution or federal legislation for that matter, was to be interpreted based on the original intent of those who drafted the text. This is reminiscent of exegesis, okay, the search for intent. But exegesis with the use of maxim allows, nonetheless, a bit of wiggle room whenever the original intent is not clear, and we have moved gradually in the civil law to a purposive approach. The same tendency has occurred in the common law world, though, however, with a traditional resistance of those who like to go back to textualism. In the UK, it's very late in history that you see the purposive approach gaining traction. It is again under European community law and later on European Union law influence. And if you look at cases that have been decided in the very late 70s and in the 1980s, you see some judges pushing forward the purposive approach. And in England, they said, hey, remember our past. The mischief rule that was used in the Middle Ages was geared towards trying to identify the purpose. Why do we adopt that legislation? And let's make sense of it based on this why, on this sense of purpose. But it is done in the contemporary period more to avoid restrictive interpretation and rather to go to expand a little bit when it seems reasonable to do so, the meaning of words that are used in a statute. So you see, and I have voluntarily put in parallel, development in the civil law and in the common law, Never mind if you missed a few nuances out there, because we will revisit this in the second video. So to wrap up on that first presentation, the literal and grammatical interpretations have never been fully abandoned, neither in England nor in the United States or in Canada, Australia, or New Zealand, in common law jurisdictions in general. Many judges continue to interpret statutes restrictively, and this tendency tends to be predominant when you are dealing with fiscal legislation. And another point that you must keep in mind, and this is now essential, and it will be developed in the next video, restrictive interpretation does not create a vacuum, okay? It's not like the fear of sending people home without a possible remedy or solution that we have identified in the civil law. There is no gap, because when the statute does not control, case law takes over and it applies by default. The fact that a situation is not covered by statute is not a big deal, and it happens oftentimes so detailed the provisions are. When this is the case and judges say, okay, your claim is not covered by statute, you do not benefit from the statutory remedy, let's see what the common law has in stock. You go back, you revert to case law, and yeah, the snag is that more likely than not, the case law has not yet developed to create that remedy. And actually legislation has done it, but it may be in a shy manner, and you will always have a tendency in the court in common law jurisdiction between one party promoting the literal and restrictive interpretation and the other one trying to stretch the statute, having a clear sense that you're not going to find a proper solution based on the cases. So you must master both method, literal and purposive approach, okay, to be able to argue your case, one way or the other, or to try to make sense of the final judgment whenever you put your attention on a court decision. So I'll conclude by saying that statutes, whatever they are always to be regarded as special law that create an exception to the common law or case law. The common law is the general law, where you always the hope, if it's not covered by the special law, go back to the general law. And I will leave it there because the conversation will continue in the next video. Thank you for your attention. If you find that video a little bit complicated, do not hesitate to watch it another time. Au revoir. See you next time.